Hello everyone, welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann.
And hello everyone, I'm Shauna Sanford. Welcome to the show. Drug charges are among the most serious in the criminal system. They can carry severe penalties at both the state and federal levels. Louisiana has the distinction of incarcerating more drug and non-violent offenders for longer sentences than the national average. That's according to Governor Bobby Jindal's office.
Our guest today is no stranger to the criminal court system. Attorney Joe Marino represents defendants every day who have been arrested for various crimes, including drug charges. He will join us in a few minutes to discuss what you need to know about drug offenses.
Looking forward to hearing what he has to say. Lots of really great information. But John, before we get to our guest, talk a little bit about, based on your experience, some of the most surprising things that you've discovered in dealing with folks who have drug offenses.
All right, well, I should be clear, and I want to make sure that everybody understands. I am not a criminal defense attorney. That's why we invite Joe Marino here to share this with us. I'm a personal injury attorney and an insurance claims attorney. But over the years, my involvement in the legal system has taught me this. We incarcerate more drug offending defendants, people who are non-violent, than just about anybody else. And we are incarceration central in Louisiana, I think more than any other place in the world. And so it's a big topic of concern. It costs us tens of thousands of dollars a year for every single person we incarcerate. It's a big concern, and it costs our taxpayers tons of money. And I'm looking forward to having an in-depth discussion with Joe Marino about drug offenses, which is a serious concern, and are there other ways we can deal with drug offenses, and what are the drug offenses that land so many people in jail?
That's right, we have a lot to get into, so stay tuned. When we come back, we will have our guest, attorney Joe Marino. Stay with us.
I am for the child who lives in motels, cars, and shelters, now in foster care, a group home, where he sleeps not on a bed, but on a temporary cot. He is the child I am for. I am a CASA volunteer. I am you.
Hello everyone, welcome back to the show. Well, according to the FBI crime stats for last year, of all drug possession arrests made in 2012, 42% were marijuana related. In fact, more people were arrested for marijuana offenses alone last year than for all violent crimes combined. But what does this really say about our system?
Joining us today to help answer this and other questions about drug offenses is attorney Joe Marino. Mr. Marino is a local attorney specializing in criminal defense in Jefferson Parish. He is a member of the Gretna City Council, a Kenner Gretna Police Academy instructor, and a frequent lecturer. We welcome you. Thank you for being with us. We got a lot to cover today. This is a major, major topic of conversation. It's crowding out our jails. All these people who they got into trouble with drugs. Either they were using drugs and they got caught for possession. Some were arrested and convicted, or they pled guilty to possession with intent to distribute. That's a big part of your law practice, primarily in Jefferson Parish. How would you define, just give us the layperson's definition. What is possession of drug offense? What is possession with the intent to distribute?
Well, possession of drugs includes your obvious, your marijuana, heroin, cocaine, those things. But drug offenses also include prescription painkillers that people that are possessing without a valid prescription, if you've taken pills from a friend, or and the law with drug crimes today also includes any prescribed medication. If you're in possession of it and you don't have a valid prescription, you can be arrested, and it's a felony offense.
So if you have medicine prescribed to your mom or to your brother and they share it with you, you're in violation of the same drug laws.
That's right, and people generally easily associate that with your narcotics, your pain medication, but it also applies to anything that's prescribed. If your mother has a prescription for poison ivy for an ointment, and if you have that and you are not you don't have a valid prescription for it, that's a felony offense. It's called a violation. It's a legend drug is what it's called, and that's against the law. It's also against the law for your mother to give it to you, but I don't think you want to turn your mother in if you got caught.
Well, and I think it's important for you to define that word distribute, because people may hear that and think, well, she didn't sell it to me. I didn't buy it from her. What does it mean when you say there's the intent or there is distribution?
Right. That is a common misconception with distribution. People think if you didn't sell it, then you haven't committed the crime of distribution. But distribution is just a transfer from one person to another. I mean, it's as simple as technically two people sitting in a car smoking marijuana. Each time one passes it from one to the other, and it's a transfer, he's committed the crime of distribution. Right. And when it's transferred back, that's another distribution.
So just giving it to somebody, just handing it over.
Transfer from one to another. That's all a distribution is. Possession with intent to distribute means that you have an amount that they determine is not intended for personal use, and there's different factors that are going to go into that. You're talking about when they charge you with possession with intent to distribute, the factors that they're going to look at is the amount, packaging, whether it's packaged for sale, whether you have numerous small bags, whether there's scales involved in the arrest, large sums of cash, small denominations, multiple cell phones, guns. It's always on a case-by-case basis for possession with intent to distribute. But the gist of it is that it's an amount that's not consistent with personal use.
And different drugs are treated differently.
That's correct. Different drugs carry different penalties, and they're in different schedules. So,
and we were talking about this in preparation for filming today. Most drugs, if you are in possession of them or you have them and they charge you with intent to distribute them, those are felonies. There's one drug that if you have simple possession of that drug, that's a misdemeanor, and that's marijuana, right?
That's correct. That's the only drug that you can be in possession of where it would not be considered a felony offense.
The first time.
Marijuana, correct. And that's another misconception, or maybe not a misconception, what people don't realize. If you're in possession of marijuana, it's a misdemeanor. You can get up to a $500 fine and up to 6 months in jail, and people plead guilty to that all the time. What they don't realize is there is no time limitation for a second offense. Can be 10, 20, 30 years later, but a second offense, possession of marijuana, any amount, can be prosecuted as a felony. Third offense as well. Third offense carries up to 20 years in prison.
Wow. Amazing.
That is incredible. You sit on a sentencing board, right, that deals with sentencing as it relates to various offenses. If you could speak to just how widespread and how serious this problem is in dealing with drug offenses, and really the approach that you all are now looking at, and the state really in general, because, I mean, we're talking about a lot of people who are going to jail on drug offenses, and it's costing taxpayers a lot of money.
That in my opinion, is the motivation behind these changes in the legislature. Nobody in the legislature wants to be known as soft on crime, but when you have jails that are crammed full of people on possession offenses like we have in the state of Louisiana, you simply can't afford to incarcerate all these people. And so the Louisiana Sentencing Commission, I'm on the front end committee for that. We meet, and some of the things that we're looking at for this year, for this upcoming session, is minimizing some of the penalties for possession offenses to try to minimize the jail populations, because it just simply costs too much money to incarcerate people.
And I want you to tell us more about that, but before we get into that, what others are on this committee? It's not a bunch of criminal defense lawyers, right? It's a broad spectrum of people putting in their
the group that's actually comprised of the Louisiana Sentencing Commission is made up of district attorneys from across the state, sheriffs, law enforcement. You have some private criminal defense attorneys like myself. I'm not on the committee. I'm on the front end committee, not the actual sentencing commission. It's a smaller group, but it's people from all aspects of the criminal justice system, including people that work with the prisons and the Department of Corrections. They're also in favor of putting together different alternatives to just incarcerating people for possession offenses.
Right, because there's marijuana, which is the only one that in the first offense setting is a misdemeanor, but everything else, cocaine, crack, heroin, everything else is a felony.
Pain medications.
Yeah, prescription drugs is another thing that if you're in possession of a prescription drug not prescribed to you, that's a felony offense.
Felony offense.
And that can result in jail time as well.
Well, even though you may get probation for it, you have to go through a long and complicated process to eventually try to get that taken off your record. But it never truly comes off your record, even if you do get the conviction set aside and do get an expungement later. Law enforcement always has access to your arrest record. So each and every time you are ever pulled over for a traffic violation and they run your name, they will see that you were arrested for this offense.
So I think that's very important. If you can get something expunged or you try to get something expunged from your record, it's not as if it's wiped clean. I mean, it is still there to some degree.
There are many different agencies which always have access to your, with law enforcement being one, they will always have access to that. It's removed from public view.
Okay.
But even that, it's not, expungements are a complicated procedure. It's overly complicated. But in order to be, to even get to the point where you can get an expungement, you have to have entered a plea under a provision of the code that, where you made an agreement that you're going to receive probation, successfully completed, then go to court and ask the judge to allow you to remove this and set aside this conviction. And then after that, then you go back to court again with a motion for an expungement to remove that arrest from your record from public view. It's complicated.
Let's talk a little bit broadly for a minute. How many, what does it cost the taxpayers every time we lock somebody up in jail? Cost per year if you...
it's north of $30,000 a year. But there's so many more costs that people don't even think about. It's not just the cost of the guy who's incarcerated. What about the spouse that he's married to that can no longer afford to make the car payment or pay the rent or pay the mortgage? What about how difficult is it going to be for the guy once he gets released? If he had a job going in, he's probably not going to have that job when he gets out. So now he's going to have to go out and try to look for a job while he has a felony conviction and is on parole, as opposed to alternatives such as drug treatment programs and diversion type programs where you could try to make a better impact on his life and everyone as a whole. It's not just the person that we're trying to help.
And again, for the benefit of our viewers, a diversion program, you want to define that?
Right. The district attorney's office, in every jurisdiction is different, but the district attorney's office, including the one in Jefferson, they have a diversionary program where if you're a first offender with no prior convictions and you're charged with a crime that's not a crime of violence, like a possession offense, possession of cocaine, you can go in, they can suspend the prosecution of your case, put you through their own program, which usually includes things like counseling, drug treatment, drug testing, those types of things. And if you successfully complete that, the charges against you are dropped.
So the idea of this diversionary program, rather than spending $30,000 or more to incarcerate you, where you don't get rehabilitated, you just have a year or more of hell. You get
or even probation.
Counseling.
Or even probation. I mean, if you plead guilty and you're placed on probation, the probation officers can only supervise so many people at a time, just like you can only incarcerate so many people at a time. So do you really want your probation officers spending all their time supervising possession offenses when they have other crimes or more serious or more people that they would really need to be watched a little bit more closely than a otherwise law-abiding citizen who was arrested for a possession offense?
And so, and that program is available to people who are, if it's a first offense, regardless of what sort of illegal substance they were charged with?
Generally.
Okay.
Yes.
All right. Okay, listen, we have to take a quick break. We're going to continue the conversation, and when we come back, we're actually going to take questions from our viewers. So stay with us. We'll be right back with attorney Joe Marino.
We can beat this. The spill in the Gulf is a catastrophe.
But we will solve it.
This is not a Gulf Coast issue.
This is a national problem that requires a national solution.
But what can you do to help?
What do you have to offer? Your voice.
Speak up.
Add your name to the petition
Demanding restoration and protection
of America's Gulf Coast.
Sign it.
Share it.
Be the one.
Be the one. RestoreTheGulf.com.
Welcome back to the show. Our guest today is Attorney Joe Marino, and we are talking about drug arrests and convictions. And you all have lots of questions about this topic, and we're going to get right to them. Our first question comes from Nick. He says, what happens if I'm pulled over while driving my vehicle and a cop learns that the passenger in my vehicle also has drugs on him? How can the cops claim that I knew about it or didn't? Will my car be seized?
It's about 2 or 3 questions
Yes.
in one. But with regards to possession, you can be charged with possession even if you're not in actual possession, even if it's not on your person. You can be charged in possession, which is called constructive possession. And then the main thing that the police would have to prove in order to charge you with something that someone else has is associating you with it in some way by guilty knowledge. What connection do you have to the drugs that are found in the vehicle? Do you have dominion and control over it? Is it it can be yours without being on your person.
Yeah, so if you're in a car with someone and that person is possessing marijuana or some other drug, you get stopped, and the cop wants to charge both of you, which is what Nick is saying here, wants to charge both of you with possession, that probably is going to happen. I mean, it's likely that that is actually what's going to happen, right?
Everything's on a case-by-case basis, but I mean, there's a lot of factors, again, even with possession, as to who's going to get charged. Where was it found? Is there any evidence of recent drug use? Is there any evidence that you've used? Are you in possession of some type of drug paraphernalia, you personally, on your person? Did either you or the passenger make any statements regarding who the drugs belong to? The police officer may have actually observed you to actually have it in your possession and transfer it to the other person.
What about the vehicle? Will the vehicle be seized?
Vehicles can be seized in connection under that forfeiture law, just like money can be seized if it's used to facilitate a drug transaction, or cash if it's proceeds of a drug transaction. That's that whole forfeiture proceeding. That's a civil proceeding that they can start against you. Yeah,
and let's talk about that, and we're going to talk about it more in the episode. We're going to do 2 shows on this drug offense topic, but under the forfeiture law, if the police arrest you for a drug offense and they find cash in the same vehicle you were in when you're pulled over, and they suspect the cash is related to the drug offense, they can seize the cash. That's under this forfeiture law that you just referenced. Right. Or if you own the vehicle and there's not the bank doesn't own the vehicle, like you're paying a monthly note on the vehicle, if the police, if they want to, they could seize your vehicle and say, we think the vehicle was being used in delivering the drugs. That's another thing that they might choose to do. Correct. And within 30 days, you were explaining this to me before, right. You have to file something. The way it works,
when the police seize something, and let's just use cash because it's an easier example, if the police believe that your money is connected to drug activity, whether it's from selling it or about to be used or it proceeds, anything to do with any connection to the drugs, you have 30 days to file a claim. Once they give you this forfeiture notice, you have 30 days to file a claim. And the way the forfeiture law is, it's almost backwards. It's backwards in the sense that you then have to start trying to prove that your money is not drug related. Or that, and so you file a claim within 30 days to say that I'm the owner of the money, this is the source of the money, it's not involved in illegal activity. And if you don't do that, if you don't file that claim, your money is forfeited and gone forever. Even if the district attorney drops the charges, even if
the drug charges.
The drug charges, even if you're not even prosecuted, even if they never accept those charges, if that claim is not filed within 30 days, you've lost all your rights to it, and there are no exceptions.
And there's nothing that you can do about it at that point.
There is nothing you can do about it at that point, which is a good reason why if you are arrested and money is seized from you or a vehicle, then you should contact an attorney immediately because you're on the clock.
Well, interesting, John, you mentioned what if there's cash in the car, but what if there's a gun in the vehicle?
Right. That's another aspect that a lot of people don't understand or they don't appreciate. You can be in lawful possession of a gun. You can have a concealed weapon permit. Or you can just simply have a gun in your vehicle, which is not illegal.
That you're the lawful owner of.
Right. Lawful owner, it's my gun in my car. That's not against the law. But the 1495E, that statute says that if you're in possession of a firearm or have a firearm under your immediate control, and you're also in possession of any controlled substance, any drug, you are then subject to a mandatory 5-year imprisonment if you're convicted of that offense.
Mandatory 5 years.
5 to 10.
5 to 10 years.
That's correct.
Yeah, and you know, that just brings up all kinds of concerns, and what that tells me is if you lend your car, maybe you got a teenage son and he's out with his friend, you let him take his friends out partying with the car, you better check that ashtray, make sure that nobody's doing anything that they shouldn't be doing, because if the police pull you over and they find a marijuana cigarette butt in that ashtray and you've got a gun in the car, you might find yourself in some real hot water.
Well, the first problem you're going to have is that when they arrest you and bring you to jail, you're going to have a pretty high bond, because you're charged with a very serious crime that is a mandatory jail offense, and you're going to have to post a high bond even just to get out of jail to fight that charge.
Well, this is really interesting. We were talking about this a little bit earlier, about how these situations can affect immigration. You were mentioning that you handled a really interesting case of a young woman who was in a car with a friend of hers. She was a legal resident but not a legal citizen, is that right?
That's correct. And she
tell
was
us
a
about
passenger in a vehicle, and the boyfriend was purchasing drugs that she was not involved with. She had nothing to do with it, didn't even know that that was his intent when he met a friend of his. When the police came, the drugs were dropped on the ground. She wound up being charged with possession of heroin. He wound up being charged with possession of heroin, and we actually had to go to trial because they could not only could she not plead guilty and get probation because she would be subject to deportation, she could not even participate in a diversionary program where they don't prosecute you because under the immigration law, and I'm not an immigration attorney, but I'm not an immigration attorney, but you are subject to deportation if you attend a diversion program, because that's an admission of guilt.
Right, yeah. So, I mean, the warning there for viewers, if you are legally in the country and you are applying for citizenship, if you have a green card, if you even have citizenship, if you plead guilty to a crime, certainly felonies and perhaps even some misdemeanors, but talk to an immigration attorney, you may be putting at risk your legal status. So absolutely talk to an immigration attorney and make sure, if you have a criminal attorney, that attorney is in the loop about this and that you're consulting with an immigration attorney.
It's part of the waiver rights forms now that in Jefferson Parish, on all the forms, they will advise you that there are possible immigration consequences if you are not a U.S. citizen in connection with a plea of guilty to a felony offense.
Okay, we have another question from Jeannie. She says, a friend of mine had tobacco rolling paper in her pocket when we were stopped by the police. The police tested small particles I found inside the rolling papers. Can you be arrested for particles?
There is no minimum amount. If it's enough that the police can test and detect the presence of a controlled substance, marijuana, cocaine, anything, that's possession, and that's a crime.
So talk a little bit about what it might cost someone to come and who might need your services or the services of a criminal defense attorney.
And at what point should they consider contacting a criminal defense attorney if they've been arrested?
Well, I mean, at what point is the easier of those two questions? Immediately. When you're arrested, the first thing that's going to happen when they take you to the jail after you're booked is a bond is going to need to be set. If you hire a criminal defense attorney, that attorney can get involved immediately with your representation, which could include meeting with and speaking to a judge about setting a bond for you, or possibly authorizing a signature bond to have a family member or parent sign a bond to release you from jail, as opposed to having to pay a bail bondsman.
So a signature bond costs nothing if you can convince the judge to allow that.
If you qualify, and again, that's on a case-by-case basis, depending on whether they've been arrested before and how serious the crime is. And then the next step in the process between your arrest and when you first go to court, which is going to be about a month later, the district attorney's office is going to be reviewing the charges to decide what to charge you with, if what crime or not. And if you have an attorney involved in the beginning, and you're not appointed an attorney until charges are filed, but if you hire an attorney in the beginning, you can have your attorney meeting with the district attorney to present any evidence that's favorable to you, information about you, maybe witnesses, maybe other facts and information, other than just the police version of your arrest, which is all they would be considering without an attorney.
And I'm sorry, you may have said this, but what if you can't afford an attorney?
Right. If you can't afford an attorney, you're not entitled to have an attorney appointed to you until after the charges are filed. And at the point of arraignment. At the point of arraignment, when you go into court, before they have you enter a plea of guilty or not guilty, they're going to ask you, can you afford an attorney? And the court is going to go into a discussion with them if they say no, to see if they qualify for a public defender.
But most criminal defense attorneys, they will set a fee, and typically the fee is it's a set amount.
That's correct. Most, I say most, including myself, operate with basically what's called a flat fee. It's a fee to represent you on the case from the beginning to the end, whatever the resolution is, whether it be by dismissal, by plea, or even motions or trial. It's a flat fee that's not an hourly fee.
It depends on the severity of the charges and whether or not you've had prior criminal convictions, which means the stakes are higher.
That's correct. When I'm evaluating a case to decide what kind of fee to charge for the flat fee, I'm looking at whether they've ever been arrested before, have they ever been convicted of any crimes, how serious is the crime that they've been accused of, and I'm going to factor in my time from my experience to see what do I think this is going to take for me to help and resolve this.
And that's fairly typical.
That's pretty much the way most criminal defense attorneys do that.
Well, we have lots more that we want to talk to you about, so we need you to stick around for the second show. Will you do that?
Sure.
All right. That is all the time that we have this week on Power of Attorney. Thank you so much for joining us. Be sure to join us next week when we will continue our conversation with attorney Joe Marino.
And of course, we will include you in the conversation, so start sending your questions through Facebook, email, and Twitter. Also, visit our website, johnredmannpoa.com, for more information. Thanks for watching, and we will see you next time.